Good evening, everyone. On behalf of the Hampton Bays Public Library, I would like to welcome you to Keeping It in the Family, How to Make Your Trust Bulletproof with Britt Berner. A little bio on Britt. Britt is the driving force behind Berner Law's Manhattan office, serving clients from New York City to the East End. Britt has been named a Super Lawyers Rising Star for her 6th consecutive year, an outstanding woman in law by Hofstra University School of Law, and a caregiver champion by Caring Kind. Britt is the immediate past chair of the New York City Bar Association Committee on the Legal Problems of the Aging. She is the treasurer of the New York State Bar Association Elder Law and Special Needs Planning Section. In addition to her Bar Association responsibilities, Britt is a charter member of the Advisory Council for the Katz Institute for Women's Health at Northwell. The Katz Institute is a leader in women's health, dedicated to improving the quality of life for women by providing educational resources, prevention, wellness programs, and clinical care. Britt is licensed to practice law in New York State. She lives in West Hampton and downtown Brooklyn. Welcome tonight, Britt.
Thank you so much. I'm so happy to be here, and I'm happy to hear that you say you're going to start up with some in-person events in the fall. I know at Berner Law Group, we are starting with some in-person events. Yesterday, we had one in Southampton, and we're really excited to get back in front of people. It's great to be able to come to people from our living room to yours, but it'll be really nice to see people in person again. Come back to the library. Although you guys are fully, as you said, fully operational, so that's great.
Yes.
Yeah, great. Okay, well, thank you everyone for joining us. Exciting news at Berner Law Group is also that as of, I believe, starting on Monday, we have an office in East Hampton as well. So for those of you who are further east and don't want to come and fight the traffic to West Hampton, we'll be happy to see you in our East Hampton location. So we're very excited about that. So today we're going to talk about trusts. We're going to talk about what a trust is. We're going to talk about how to, as we say, keep it bulletproof or ironclad. And all that really means is the purpose of creating a trust is often to create a protection for something. And you want to make sure that whatever you're trying to protect your beneficiaries or yourself from, that you honor the terms of the trust in a way that you can achieve that protection goal. And we're going to go through the different reasons, the different kinds of trusts, and what we suggest you do. So just right off the bat, I want to start with what is a trust? A trust is a document. So first and foremost, we have to create a trust. Many people know that when you create a last will and testament, you actually create a document that you sign in front of witnesses that says what happens with your assets upon your death. The trust includes that same information. It says what should happen with your assets upon your death. But the difference is that a trust also says what the rules of the game are while you're still alive. And when I'm talking about this type of trust, I'm talking about a living trust. So if I'm creating a trust while I'm alive, regardless of the terms of that trust or what it is a living trust because I'm creating it while I'm alive. That's as in the opposition to a testamentary trust. A testamentary trust is a trust created by someone else through their documents. So if I have a last will and testament that leaves everything in trust for my daughter according to the terms of my will, then at my death, that testamentary trust is created for her. But a living trust is what I'm creating while I'm alive. The most important thing when you create any type of trust while you're alive is that you fund the trust. So what does that mean? I have clients ask me all the time, what does it mean to fund my trust? You have to put things in it. So if my trust says the rules of the game as to how the money should be managed while I'm alive and what to do with it when I die, and if it owns a property, selling that property, who it goes to, all of that, that's all well and good. But if my trust doesn't own those assets, it doesn't accomplish anything. So you create the trust, you sign it into creation, and then you actually change the ownership of certain assets of yours so the trust owns it. So if in my example you have a house and you want your house to be owned by your trust, and at your death, your trust says where it passes to, well, then you need to sign a new deed that transfers ownership from you to your trust. And the trust now becomes the owner of that property. And whether or not there are tax consequences to that or anything else, all depends on the terms of the trust. So what I'm describing right now is any type of trust that you create while you're alive. You will notice if you have a trust that likely the last page is a document that is titled Schedule A. And a lot of clients say, what does this mean? And it usually says something on it like $10 cash. Well, that is a symbol that there is something in your trust when you create it, because you can't have an unfunded trust. But we want you and encourage you and often assist you with putting other assets in your trust. So if I sign a deed putting my home into a trust, I would then put the address of that property on the Schedule A so that my trustee, if it's going to be someone else, especially after my death, they know what assets my trust owns and they're in control of. If I have a brokerage account with my financial institution and I change the owner with the financial institution to be my trust, I would then add the account number to the Schedule A so that the Schedule A reflected that that account was owned by my trust. Now, this is a document that might change over time. You may sell the property that you originally put in the trust and put that money in a bank account. The bank account would go onto the Schedule A. You may then use the money in the bank account to buy another property. So you'd cross out the bank account if there's nothing left in it and put the address in the new property. So a Schedule A is a working document that you can continue to change as the assets in your trust change. Now, not everybody's trust is going to have a Schedule A that will change over time. For many people, they will put assets in their trust when they create the trust, and those assets will be the assets that remain in that trust until the day they die. So that won't apply to everyone, but that's what that Schedule A is. It's a list of what your trust owns. People used to just put an asset on the Schedule A, and that would mean the trust owned it. That's not going to be sufficient. You need to actually change the title of the account or the title of the property with the appropriate entity. So be it a deed that gets filed with the county clerk, or if you have a co-op, your co-op that the co-op shares and proprietary lease actually have the name of the trust as the owner. For that bank account or brokerage account I was talking about, the name on that statement, the owner of the account is the trust. You actually have to change the ownership. So now let's get into different types of trusts. So there's, in the very broadest category, we talked about living trusts and testamentary trusts. And now we'll talk about different types of living trusts. And again, a broad category is revocable versus irrevocable. Revocable is exactly as it sounds. It is a trust that can be changed by you, revoked by you. You can amend it. You can put assets in, take assets out, use them for your benefit, give them away to someone else. You can do whatever you want because the terms of the trust are wide open. And if I create a revocable trust, that's the Britt Berner Trust, and I am the trustee of the trust, while I'm alive, that trust has my social security number to identify it, and I can do anything I want with it. When we start to talk about making your trust ironclad, when we talk about revocable trusts while I'm alive, the only thing that I'm making the trust ironclad or bulletproof from is probate. I'm avoiding the court process of probate. One of the most confusing things for most people that come into my office is that they don't understand that if you have a will and you need the terms of it to be followed, it must be probated. You can't have probate without a will, and you can't have a will without probate. They go hand in hand. So if you have assets in your sole name with no beneficiary and you have a last will and testament, that will needs to go through probate so that your executor can be appointed by the court and then can collect those assets that are in your name and distribute them to the people or the institutions that your will says they go to. If you put your assets into a revocable trust, remember, you're changing the ownership. So you no longer have assets that are in your sole name without a beneficiary. They're in the name of the trust. And the trust, by its terms, says, this is how I want you to handle the assets while I'm alive. And in my revocable trust example, I'm in control. My trust might say, if I become incapacitated, this is who I want to be in charge and be the next trustee. And these are the things that I want them to make sure I'm taken care of, make sure my spouse is taken care of. Maybe I want to make it permissible for my trustee to make sure my children are taken care of. That would all go in the terms of the trust. And then it would say, upon my death, the trustee would be, and it would name the name of the trustee, and then say what I want to happen with the assets. Do I want them sold? Do I want them distributed out? Do I have house to this person, cash to this other person? Whatever your wishes are. But it doesn't require that court process of probate because those assets are not in your sole name. And say it's a bank, the bank knows who to give the assets to because the trust document, which is the owner, tells them what to do. And so that when you create a revocable trust, you're really doing it for the purpose of avoiding probate. Now, why would we want to avoid probate? The main reason to avoid probate is if you have a situation where you might believe that there's going to be a lot of delay and costs in the probate process and probating your estate and what that means. So I'll give a few examples. The probate process, without getting too much into it, requires, regardless of who your assets are going to go to under the will, the probate process requires that your next of kin are notified that your will is being probated. So if you are a person who has a spouse and children, that's who receives notification that your will is being probated. If they don't contest, it will go through. But take the person, and if anyone on this has heard me speak before, you've heard me talk about one of the worst ones I ever saw, which was a gentleman who died in his 90s. He had two friends that were the beneficiaries of his estate and the named executors under his will. I didn't know him while he was alive, but his friends came to us after he died, and there was a last will and testament that named them as beneficiaries and executors, and there was one brokerage account. And they said, how do we get our money? We said, well, we have to probate the will, and we have to give notice to his next of kin. And then they said the thing that I hear all the time, he has no next of kin. Everyone has next of kin. The problem is some people don't know who they are, but we all, if you follow genealogy, at some layer will find a person of relation. And so the problem is when you have someone who does not know who their next of kin are, you end up in a situation where you have to hire a genealogist and go through your due diligence of trying to find that person. And if you've ever seen those little death notices at the back of the newspaper, that's what it is. Those are people who have to find the next of kin or satisfy the court that they were looking for them so they can probate that will. That's why those death notices are in the newspaper. They're told they have to publish in that newspaper. And so if you don't know who your next of kin are, because this gentleman had no siblings, never married, or I should say, never married, no children, no siblings. His parents were deceased. His parents, I believe, had siblings, but both parents were born in foreign countries during a war. It was unclear where the parents' siblings went when the parents came to the United States. And we had to hire a genealogist, and it was about 2 years later before that will actually went through probate. Also, this one account could go to these two individuals. There's a lot of ways to avoid probate, and there's a lot of reasons why you would do a trust or name beneficiaries on an account or something. But for my purposes of this conversation, if the trust had owned that account, the trust could have said, upon my death, this goes to my two executors, my two best friends, and it would have gone to them. And that would have been the end of it. There wouldn't have been this search. So if you're disinheriting one of those next of kin, if you know who they are, you don't want to go through probate. You don't know who the next of kin are, you would like to avoid probate. If you own property in multiple states, say I own my house in New York and a house in Arizona and a place down in Florida, if I have a will and all those assets when I die are in my name, my will needs to be probated in all 3 states. So that's time and money. So in that case, I would probably want to create a trust and put all those properties in the trust so they can be distributed. We also have, if you have a disabled beneficiary, you may want to avoid the delays of the courts naming a guardian ad litem who gets fees for doing a report, so the disabled beneficiary is represented. So there's different reasons you might want to avoid probate, but that's what a revocable trust is going to do. It's going to avoid probate. The other reason, that's a newer reason why we want to avoid probate, is that we saw that when COVID started, the courts shut down and there was this enormous delay in getting estates through probate. And we're still seeing a delay. There's backup and the process has changed. And so the delays of COVID, if nothing else, have shown us that anything can happen, and that the least amount of process that we can surround your estate with, the more efficiently the assets will go to whomever you've named as beneficiary. And the last big reason that we like to avoid probate is because if my documents say that upon my death, I leave everything to my daughter and I leave it to her in trust, and we're going to get into what those trusts look like, but I'm leaving it all to her in trust to protect her in some way, and that is created through my will through probate, well, then every time there has to be a change to that trust, so let's say my daughter gets older and can't be trustee anymore and I need to name a new trustee needs to be named. I'm deceased because my will's been probated. A new person needs to be named. They have to go back to the court and get new letters of trusteeship from the court. It's more process. Again, more delay, more money. And so if we're going to have these ongoing trusts that might continue on for more than one generation even, we definitely want to avoid that constant court involvement that is just time and money. Then we move on from revocable trusts and we go to irrevocable trusts. And when we're talking about irrevocable trusts, we can be talking about many different types of trusts. I'm going to highlight a few of them today, but there are many types of irrevocable trusts. And what it really means to have an irrevocable trust, the way I like to think about it is there is something in the terms of that trust that limits me as the creator of the trust from handling those assets. And depending on the reason that I'm creating the trust, that's going to be what the terms are and what I'm limited in doing. So I'll give an example. One type of irrevocable trust that we often create for clients is a Medicaid asset protection trust. This is a trust in which we put a client's assets so that the assets can be saved to be passed on to whomever they want them to go to, and they can qualify for government benefits, most specifically for Medicaid to cover the cost of home care or nursing home care. So if I take my home and I take a $30,000 bank account and I change the owner on both to be my Medicaid asset protection trust, I'm limited in a few ways. One, I'm not the trustee of that trust. I need to name someone other than myself or my spouse as the trustee of that trust. Two, I can receive income from the trust, but I can't receive principal. So what that means is if I rent out my house because I decide to go move in with my daughter, or I go to a nursing facility or something else, the rental income is still my income. So that's a good thing for many people. They want to make sure they still have their sources of income. If I have that $30,000 bank account though, that $30,000 cannot be used for my benefit. Because if it could be, Medicaid would say, great, then give me the money. We're not going to pay for your care, you pay for your care. And so being denied access to principal is one of the main things that makes that a Medicaid qualifying trust or an asset protection trust. This is the number one thing that we need to stress to clients when they come in about the bulletproof ironclad concept is that if you are putting assets into a trust for the purpose of protecting yourself and your loved ones so that those assets pass to them and that your care could be paid for through the Medicaid program without those assets being counted as your own for eligibility purposes, you must honor this rule that you don't use trust assets for your own benefit. Now, your children or anyone else that you choose to name in the document are permissible beneficiaries of that money, but you are not. This is incredibly important to keeping the integrity of that trust so that if you do apply for Medicaid, they don't come back and say, well, you're saying your house and that 30,000 is protected, but we know there was 35,000 in there and you used 5,000 of it on your own and you weren't allowed to. And so you don't have that protection anymore. So it's really important that you don't use principal from those Medicaid asset protection trusts for yourself when you're the creator of the trust. Other types of irrevocable trusts are, for example, we call them Islets, irrevocable life insurance trusts. Now, the purpose for creating an Islet is to take a life insurance policy of which you're the insured and the owner and remove it from your estate for tax purposes and put it in the trust so that when you die, the death benefit doesn't count as in your taxable estate. So let me give an example. If you have life insurance that says that I have a life insurance that says that upon my death, my beneficiary will get $3 million. I have a $3 million life insurance policy. That's the death benefit. If I die and I have a house and maybe I have an apartment and I have a summer home and I have some cash assets and they all equal $4 million. And then I have a death benefit of $3 million. Then when I die, I have an estate of $7 million. And New York State estate tax law says that if I have more than 5.93 million when I die, that's the 2021 number, then my estate is going to owe estate taxes. And they're going to be fairly hefty estate taxes. So what I want to do is take that $3 million life insurance policy and move it over here, move it out of my estate. So now I have $4 million in my estate of my house and my other money. And there's under the 5.93 million. So I have no estate tax. And that 3 million is still passing out to my beneficiaries. And so again, we do an irrevocable trust for any reason to give protection. And here we're protecting against estate taxes. Same thing, you can't control that life insurance policy or be the trustee of that trust. So for some people, they have to wrap their head around that loss of control. There's other types of irrevocable trusts that we do for tax planning, for people who are trying to get assets out of their estate, again, so they stay under those exemption amounts. And if you believe you're a person who is in that higher threshold amount, you should really be seeking specific advice in your case, because depending on the type of assets you have and your family structure and who your beneficiaries are, there are going to be different options for you. But again, once you create the trust, remember the trust has the rules of the game. So whether it's the Medicaid trust game or the tax trust game, whatever it is, if you violate those rules, you expose the assets in that trust to whatever it is you were attempting to protect it from. So it defeats the whole purpose of creating the trust. And so the number one rule, if I could say there's one takeaway of all of this, is that if you have a trust, you have to follow the rules of that trust. And it's you may have a trust that looks very similar to the person next to you, but it's going to be your trust with your rules in it. And so the most important thing when you're looking to protect the assets in the trust from whatever you're looking to protect it from, are that you follow the terms of the trust so that no creditor or Medicaid agency or any individual can come back and say, this trust is a sham. They didn't even follow the rules. You know, they weren't allowed to touch the principal, and they did. They weren't allowed to be the trustee of the life insurance trust, and they were. So you have to follow the terms. I talked about avoiding probate, and part of the reason of avoiding probate being so that after death, assets pass on in trust to your beneficiaries, and we keep it out of the courts. That trust we call in our office, if it's going to your family members who are your lineal descendants, we'll call it a descendants trust. If it's going for a beneficiary who's not related to you, we might just call it a beneficiary trust. Regardless of the term, it is a trust that is created within your own documents to further protect your beneficiary, whoever they are. So for the simplicity of example, I'll again go back to my example of I am leaving in my documents a trust for my daughter. Now, the first question that we talk to a client about when we're talking about creating these further trusts is, are you trying to protect your daughter from herself or from other people? Or is she disabled and receiving government benefits and you're trying to protect her from government benefits as well? We find out the purpose of the trust, because once you know the purpose of the trust, we can build in the terms to properly protect that individual. And then again, you can follow the terms, or they can, once you're deceased, follow the terms of that trust to make sure the protections stay in place. One big protector that we're always trying to protect from are creditors. And I've had clients say to me, I had a client who said, well, you know, my daughter's a doctor and she will never have creditors. Those two things seem to line up for her. And I said, well, what if she's sued? What if she's sued beyond her malpractice? What if she gets in a car accident? What if she earns so much money that she has estate tax upon her death? Those are all potential creditors that can come up. And I think a lot of people don't think beyond the, I didn't pay my bills and therefore I have a creditor. Creditors pop up in all sorts of ways. And the big creditor that we're often telling clients about is the creditor that shows up in a divorce, and that is your divorcing spouse. And you want to make sure, many clients want to make sure that if they're leaving assets behind for their child, that eventually that those assets then maybe pass on to their grandchildren and don't go over to a divorcing spouse and potentially other children that divorcing spouse has, or a second spouse, or whatever it may be. They want to keep the assets in the family. And as I should have said at the beginning, not all trusts are for the uber wealthy. So we have clients of modest means. They own their home. They have some assets, but they're not worried about a taxable estate or anything like that. But they do want to make sure that the things that they worked very hard for throughout their life go to their children or their child in a way that they're protected and that they're not taken away from them. And so regardless of the amount of money, many people are creating these trusts for protection of their children or their other beneficiaries, even with the smaller amounts in it. So how strong you need to make the trust to protect against creditors, that may depend on the size of the assets, right? So let me give an example. Very often our trusts will talk to clients and they'll say, okay, I want it to be easy though. I don't want too much confusion. I don't want extra tax returns. I don't want things to be difficult for my child. So we say, okay, well, what about if your child, if you're not trying to protect them from themselves, what about if you let your child, and in my example, my daughter, okay, so I'm going to do a document. My daughter's going to be her own trustee. She can distribute income to herself, so she can report all the income from trust assets right on her personal tax return. She can receive distributions of principal to herself based on health, education, maintenance, and support. That's an IRS code terminology as to items she can distribute to herself for. And she will only need a co-trustee or another trustee in the event that she wants to distribute assets to herself for anything other than health, education, maintenance, support. We call that HEMS, or ascertainable standards. So if my daughter, after I'm dead, wants to take $200,000 and use it, I would say your daughter should call, and I would say to her, what do you want to use it for? And if she says, I want to buy a house, I'd say, great, let your trust buy the house. And then the house is protected in the trust. The more you keep assets in that trust, the more protected it is. Now the daughter might say to me, yeah, but I don't want to own it in the trust because I have a spouse, and my spouse is going to be very angry if they don't own the house. We're making mortgage payments together. That doesn't seem fair. Well, then I'd say, okay, this is how we're going to protect your trust. This is how we're going to make your trust bulletproof. We're going to have your trust loan you and your spouse the down payment. And if we loan the down payment to you and your spouse and we sign a proper loan document, we will say that upon the sale of the house or upon divorce, the down payment goes back to the trust, and then you'll split the remainder of the equity in the house however you deem appropriate according to your settlement terms of your divorce. And then we're protecting trust assets, we're protecting your daughter, we're protecting potentially the grandchildren, and we're building in enough flexibility that your daughter doesn't feel like this money is too much of a hassle and it's going to create a problem in her house and she doesn't want to deal with it. So that's an example, and I've actually done that with a client, and it's worked out very well. When your daughter, if she were to say, you know what, I don't want to take a loan, I just want the $200,000. I want to put a down payment on this house. I want the house to be in mine and my spouse's name, and I don't want the trust to have anything to do with it. Well, in that case, I would likely have an independent trustee sign off on that distribution of the $200,000. Now, I don't have to pick the independent trustee while I'm still alive. I give my daughter the right to pick someone when she wants it. She can pick anyone not related by blood or marriage. It could be her friend, it can be whomever it is, not related by blood or marriage or subordinate to her. And that person can sign a document to sign off on that distribution. The distribution comes out of the trust. Daughter can do whatever she wants with it. No standards on it at all. And the rest of the trust remains protected and ironclad. Now, as you start to get more and more assets in the trust, let's say you have a client who has $20 million in the trust, and it's earning quite a bit of income. And it also has these large appreciating assets in it. And they're using the money in the trust to help pay for camp for the kids, to pay for whatever the regular expenses are of the household. We would advise the child, who is the trustee of their own trust maybe, that, you know what, maybe you should step down as trustee. Or maybe you should have a co-trustee that has to sign off on all of your distributions. And maybe if you take distributions of your big trust to use for the benefit of the family, you should have your spouse sign a document saying that they're not going to let that affect a divorce. Because I can put all these protections in a trust, but again, if you violate them or abuse them, then the trust is exposed. So let's say you don't have the spouse sign a waiver and you don't have an independent trustee signing off on distributions. Well, now you've been paying for camp, you've been paying for the nanny, you've been paying for school, you've been paying for all of these things to support the family, and now you're going through a divorce. And your spouse says, well, you know, they might be saying that they don't have anything, but they have that $20 million trust. And that's what our family's been living on for all these years. And I'm entitled to support based on the fact that my spouse has that asset. That doesn't necessarily mean that the spouse gets half or any portion of the trust, but if I'm getting divorced and I've been tapping into my trust to support my family, it's very possible that I'm going to have to keep tapping into my trust to keep supporting my family. And it's not going to have all those protections as being totally separate from my assets. And so again, the more that's in the trust, the more protections you might want to put in place, and the further you might want to distance the beneficiary, my daughter, from her trust. And maybe she shouldn't be the only trustee, and she should have what we call an independent trustee, the person not related to her or subordinate to her. You can go a step further and have a trust protector as well. A trust protector, and I'll give an example. We've had a good family friend serve as trust protector in a trust. They're named in the document. We as the law firm have served as trust protector, and there may never be a job to do. So let's say I'm named as trust protector of my client's trust, and everything's going to their daughter, and it's $20 million, and she's in control of it. Well, I might be named as trust protector, but until there's something for me to do, there's nothing for me to do. So I don't do anything. But down the line, let's say taxes are changing, the tax laws are changing, or my child or their child needs some kind of government benefits because of a disability. Or maybe it's that the child is getting divorced. The trust protector can step in and amend the terms of the trust, even though I, as the creator of the trust, am deceased. The trust protector can step in and make certain amendments to the trust to make it more bulletproof. And so the important takeaway here is that if you are putting assets in the trust, and especially if they're large assets that might require adjustments down the line, that you want to make sure the protection continues, well, then you may want to put a trust protector into that document so that there's flexibility for the future. And that is something that is probably not something that people really talked about 10 years ago, 15 years ago, even 5 years ago. It was kind of starting to come up, but it was not something that was readily talked about. And what we're finding as time goes on is the more and more we talk to clients, building that trust protector into their plan builds in flexibility for the future. And building in flexibility and building in the way to further protect your beneficiaries is the goal for most people in their estate planning. And so we really try to make it so that these are workable documents. And if they do have to move on throughout the generations, that they do have some sort of teeth to keep that protection as time goes on. So in conclusion, and then I'm happy to answer questions, I would say the most important thing if you don't have a trust and you think any of these things struck a chord with you is you should speak with an attorney about your specific situation. And I know that when we do consultations with clients, we ask them their information. We ask for the information of any children they have. We ask for any other beneficiaries or people they might be naming to serve in their estate plan. We ask them what their assets are, and we ask what their goals are. Because without all of those pieces of information, we can't possibly put together a plan that is going to most strongly benefit the client and their loved ones. So we really need all of that. And that just goes to show you that when you have an attorney who is really putting together a strong plan for you, they're not just drafting documents, because putting things into documents, yes, of course, we need to know what to put into the documents, but that's only a small portion of our job. We need to be able to advise you as to the pros and cons of all of those things we put into the documents, and how do you get to your final goals. And maybe, your goal is to protect yourself and protect your loved ones, but at what cost? If loss of autonomy or loss of your control of the assets is going to be the cost there, are you okay with that? And so it really needs to be a full conversation. The other thing I'll say is that the most important thing for a lot of clients, beyond having a good estate planning attorney or elder law attorney to talk this through with them, is having trusted advisors in terms of financial advisors and accountants who can be part of the team to make sure that you're being most efficient with assets and with taxes. So thank you, and we'll answer some questions. I see, as you can see at the bottom, there is a Q&A at the bottom, and we'll answer questions. So will a Slat provide Medicaid asset protection? That is a great question. So honestly, I would have to go back and look at the terms of the Slat, but a Slat, for people's benefit, is a spousal lifetime access trust, and a trust for the benefit. Basically, one spouse puts the assets in another spouse's trust in order to create flexibility and control of the assets in one spouse while removing the assets from the other spouse's taxable estate to try and create estate tax efficiency. I think it gets complicated when you talk about Slats and Medicaid, because one is for incredibly high net worth individuals who are looking to take advantage of tax efficiency, and the other is Medicaid, which looks at the assets of both spouses. And so we have to really look at the terms of the trust. But I think if that person would like further information about Slats, they should definitely give a call to get specific information about the right type of plan. Okay. So does a trust have to be maintained yearly? And if so, are fees involved? So from our perspective, we create an estate plan with the client, as I described, and there is a fee up front for creating that plan. We don't charge clients for coming in to review their plan, existing clients. There is no yearly maintenance. Depending on the type of trust you have, there may be tax returns that are required on an annual basis for assets that generate income tax within the trust. And it also depends who your trustee is. So if you are your own trustee, or if your family member is a trustee and they're waiving compensation, there will be no fees. Whereas some individuals have a bank or other institution serve as trustee, and then there may be ongoing fees for that trustee. So it will depend on the terms of your trust. But standardly for our clients, there is no, beyond taxes that in some trusts have to be filed annually, there is no annual maintenance or fees involved on an ongoing basis. Any other questions? Don't think we have any more. All right. Well, thank you, everyone. And thank you, Donna, and thank you to the Hampton Bays Library for having us tonight.
Thank you, Britt. Once again, a wonderful, wonderful presentation.
Thank you. I hope everybody enjoys their summer.
You too, Britt. And I look forward to hopefully having you back in person next time.
Great. I can't wait. I'll be there.
Thank you so much.
All right. Good night.
Good night.